Great, thank you so much. And I do believe I have some slides, so I'll just see if those will be up. Here we go. Hi, so I'm Elaine Hyshka, and as Sandra mentioned, I'm an assistant professor in the School of Public Health at the U of A, and I'm coming to you today from Treaty 6 territory in Edmonton, which is the gathering place of Cree, Blackfoot, Métis, Nakota Sioux, Iroquois, Dene, Ojibwe, Saulteaux, and Anishinaabe and Inuit people. And before I get started, I just want to acknowledge that the slides I'm about to present today were originally prepared in collaboration with Cecile Kazichkin from the Legal Network, who has done a lot of work in this area. And we're very grateful to the Legal Network for continuing to push this issue of access to SCS in Canada. So I'm going to talk to you a little bit today about how we need to immediately reform the regime for regulating supervised consumption services. Currently, it's a very narrow law that takes a case-by-case approach to approving supervised consumption services. And it's a very burdensome process that requires a long application form, multiple different criteria are considered. And really, it stifles our ability to innovate and to respond to an emergency situation that we're facing in Canada and to meet people where they're at. So the current process for getting a SCS exemption in Canada is really organized around a very narrow understanding of what supervised consumption services are or can be. It's really tied to a physical infrastructure or location, and it requires typically a whole host of policy and procedures that take significant resources to implement and are inflexible. And as a result, it leaves a significant proportion of people who use drugs unserved by this service. So I want to present some options for reforming or modernizing supervised consumption services in Canada, and I'll get to those in a moment. Before I do, I just want to clarify some of the things that are really not easily implemented in the context of SCS currently in Canada, and basically make the point that any new regime regulating supervised consumption services needs to be able to accommodate these and many more innovations and practices. So examples here include drug checking, which is not universally implemented within SCSs, non-injection forms of consumption. So only one federally regulated approved supervised consumption service in Canada offers this service right now. Saskatoon's Prairie Harm Reduction supervises inhalation or smoking. Others do supervise oral ingestion or intranasal use, but smoking is a huge barrier that has significant implications for equitable service access, as not all populations of people who use drugs are injecting. Provider-assisted injecting is another one that is a huge challenge. So not just enabling peer-assisted injecting, but also allowing staff at the services to assist people who are accessing them. Splitting and sharing, which we'll hear a lot more about right away. And also safe supply is challenging to implement in this context. And it's not just about practices that occur within the context of supervised consumption services, but also the different diversity of models that can be operating here. We've seen that the federal exemption process makes it extremely difficult for supervised consumption services to be organized and delivered by people who use drugs. It's difficult to implement models that are appropriate for women and gender diverse populations. It's challenging to implement them in residential settings, and it doesn't really have a mechanism for accommodating satellite or episodic models of supervised consumption services, such as, where people are not tied to physical geography and are moving about and monitoring consumption and trying to support people and keep them safe. So I'm going to present two options for supervised consumption services for modernizing the regulatory space or the regulatory requirements, and just acknowledge the Legal Network's work here in conceptualizing these. But essentially, we know that with the onset of the pandemic, the Health Canada did allow for class exemptions to go to the provinces and territories to make it much easier and simpler to stand up supervised consumption services as a response to the worsening national drug poisoning crisis. But these exemptions have been underused by the provinces. And so what we would propose is to lower the administrative burden on operators and people who use drugs that are looking to offer such services. The federal government could and should extend this class exemption to services that meet a very basic set of minimum criteria that are flexible enough to accommodate a diversity of services, practices, and models. And so this would mean that operators or people that are offering the service would not apply to the federal government for approval to do this. But if they could demonstrate that they meet minimum criteria, they would just be legally protected and allowed to do it. So minimum criteria that people would have to meet would have to be defined and created in consultation with people who use drugs and SCS providers. And they need to be uniform across the country to ensure equitable access. They, as I mentioned, should be broad enough. And I think, the Supreme Court decision is often cited in Insight as sort of setting the basic criteria, those 5 classes or 5 things. And I don't think that those are a barrier necessarily to using a class exemption approach. And the criteria that are set could be enacted in that spirit if appropriate. But really the emphasis would be on providing maximal flexibility for people to be able to save lives in this situation we're in, which is, frankly horrific across the country. So some examples of possible minimum standards could be for ensuring that there's a reasonable minimum number of people who are trained to administer naloxone and provide CPR. Another minimum standard or criteria could be that there is a designated person who is responsible for overseeing the operations of the service, however it's enacted. Another example would be having available appropriate equipment to provide immediate emergency care, sterile harm reduction supplies, oxygen, and those kinds of things. Having a basic set of health and safety protocols and procedures that are followed, and satisfying potentially based reasonable criteria from provincial municipal governments. Instead of requiring an exemption, it could just be that people offering the service are required to notify Health Canada that they will be offering the service within 5 days of beginning to do that, and confirm that they satisfy the minimum conditions. So, of course, though, any minimum criteria that are enacted will still hinder the innovation in the space and the ability of people to take care of one another legally without risk of criminal prosecution. And so that is why, ultimately, the most simple path forward here and most straightforward path is decriminalization, which would effectively eliminate the need for a supervised consumptive services exemption, as it would ideally, if implemented correctly, not criminalize possession or small, sharing or transfer of small amounts of substances. And we know that decriminalization obviously has been endorsed by health, social, and law enforcement organizations, and it's frankly long overdue. And so I made these slides before something significant happened in Alberta, and I just want to touch on it very quickly. I think when we talk about regulating and modernizing supervised consumptive services in Canada, we really need to make sure that provinces are not enacting barriers to accessing these services. We heard about Ontario limiting funding for supervised consumptive services. Alberta has now gone one step further and is proposing to limit anybody's ability to offer these services, irrespective of how they're funded in the province, by requiring anyone that does overdose prevention, supervised consumption, to seek a license from the provincial government. And a condition of that license is to collect the personal health number and valid identification of any person that they're serving. So to me, that is completely usurping the federal jurisdiction in this space. And even with decriminalization would pose a barrier to supervised consumptive services in Alberta. So something to watch for and be aware of as we modernize the regime. Thank you for this.
Thank you very much, Elaine. That's really troubling, and I hope we have some chance to talk about it during our Q&A later.